Hi, good afternoon, and welcome everybody. This is going to be a webcast on CSRS and FERS provisions relating to NAF service. Now, just in case you're wondering what NAF service is, I am assuming most of you know what that is since you're attending this webcast, but maybe you're kind of curious. It stands for Non-Appropriated Fund Service. So, what are we going to talk about today? Well, we're going to talk about what is NAF service and how do you recognize it? Okay, so you're going to have to be able to identify it if somebody has it, and we're going to have to talk about what exactly it is and how it affects everything. Is the NAF service creditable under CSRS or FERS? And can somebody pay a deposit for it? To get credit for it? Well, there are a whole set of rules surrounding that, and we're going to actually look at the creditability of this NAF service or non-appropriated fund service in one whole section. Also, we're going to talk about what an employee with prior NAF service needs to know about CSRS and FERS NAF rules, and when does the employee need to know it. So it's kind of important to know what you need to know. I mean, if you don't even know what questions to ask, it's really important to find out, well, what do I need to know and when do I need to know it? Also, what does HR staff need to know? That's really where this is all going to start. When you start reviewing somebody's OPF, whenever you start doing an annuity estimate, you're going to really need to, HR staff are really going to need to know what to be on the lookout for and what to identify. So we're going to talk about that. And probably the biggest question of all that I get all the time is, why all these rules? I mean, there seem to be a ton of rules, right? And why is it so complicated? Well, in essence, just to kind of summarize what we're going to talk about, there are four main rules or laws that affect NAF provisions, and some of them deal with portability issues, and some of them deal with service credit issues. Now, I'm going to explain all that in this presentation, so just kind of bear with me, and we'll walk through it step by step. For those of you who've been with us for FERCA presentations before, you know that it is a process. Well, this is kind of the same thing. And in this presentation also, if you have the slides printed out, there are a couple things I'm going to alert you to that are kind of cheat sheets that you can keep with you that'll definitely assist you whenever you're going through an OPF. Okay, so first of all, as I said, there are four laws that really affect NAF, and they're all codified under 5 U.S.C. 2805. So just be aware that they're there. Here's the timeline. The first one started in 1986. The second one was in 1990. There was another one in 1996, and finally 2001. Some of them deal with exclusively portability. Some of them deal with service credit. Some of them deal with both. So therein lies the complication. That's where things get a little complicated, because you have to know exactly what you're talking about. Are you talking about portability? Are you talking about service credit? And again, then which public laws apply to each? Okay, so it would be really simple if everybody who began in a NAF retirement plan stayed in a NAF retirement plan and retired from that NAF retirement plan, or they were covered under either CSRS or FERS, stayed in CSRS or FERS until they retired. That would make life really simple. We wouldn't need all these public laws. However, that's not the reality of the world. Unfortunately, or fortunately, depending on how you look at it, people can actually move from a non-appropriated fund retirement plan to CSRS or FERS, which is we refer to also as an appropriated fund retirement plan. So you're going to see that. And here are on this slide, there are a few timelines that show you exactly the kind of situations you're going to encounter. You could encounter somebody who began their career with NAF, stayed in it, and retired. Same thing with CSRS and FERS. If they had a period of NAF service and a break and then moved to civil service retirement system. Or in some cases, people have periods of time where they've gone from NAFs with a break in service to appropriated fund or the civil service covered by either CSRS or FERS, back and forth, over and over again. In some cases, you'll see people, like in example 5, that they've transferred from a NAF position to an appropriated fund position, either CSRS or FERS, and they go back and forth between that. So each situation is treated a little bit differently. So already you can kind of see what the complication is. Now, as I mentioned, there are 2 different ways that we deal with this service. One of them is portability or porting coverage. And basically what porting coverage is, it's similar to moving, where you take everything that you have with you. So if you're covered under a NAF plan and then you transfer to a plan that would normally be covered by either civil service or FERS, so it's an appropriated fund plan, the portability thing is that you would take the NAF with you. So you would port the coverage over. Service credit is something different. That's similar to transferring credits from one university to another. You were covered under a NAF plan. You had a period of time where you were separated or not, and you moved to an appropriated fund plan, CSRS or FERS, and you want to get credit in that CSRS or FERS plan for your NAF time. That's the difference. One of them, you're taking what you already had with you and moving it over to a plan that would have normally been covered by something else and retaining your prior coverage. The other one is you were in one plan, you moved to another plan, and now you're trying to get credit for your previous service. Okay, so there are 2 different issues, and we're going to approach them at 2 different time periods in this slide presentation because we don't want to mix them up because they are 2 separate issues. So that's probably the biggest complication, and it's one of the things that confuses a lot of people because a lot of times when I get phone calls, somebody's not really sure if they're talking about porting coverage or service credit. Okay, so porting coverage, if you look at example 6 here, we've got somebody who was in a NAF plan. They moved to a plan that was covered, that was an appropriated fund plan that would either be covered by civil service or FERS, but they retained their NAF coverage. Okay, that's what we talk about as far as porting coverage. Again, example 7 is another one where they were in an appropriated fund plan, either CSRS or FERS, and FERS actually, and then they moved to a NAF plan and they retained their FERS coverage. Okay, so that's what we're talking about by porting coverage. Service credit is a little bit different. As I said, if somebody's covered by NAF, then they move to civil service, CSRS or FERS, can they get credit for that period of NAF time? Okay, so that's really what we're dealing with the service credit issue. So again, before we even can get into discussing either of those things, we need to know what is NAF and how do we identify it? Well, non-appropriated fund retirement plans are covered by, are located with the Army, the Air Force, the Marine Corps, Commander, Navy Installation Command, the Navy Exchange Service Command, the Army and Air Force Exchange Service, and the Coast Guard all have NAF plans. So, what do you need to know if you're an employee? What do you need to know about CSRS and FERS NAF rules, and how does the employee need to, and when does the employee need to know it? Well, you need to know, first of all, if you're talking about porting coverage or if you're trying to get service credit for a previous period. So the public laws that cover porting coverage are Public Law 101-508, 104-106, and 107-107. Those are the laws that deal with porting coverage. And again, that's taking the coverage that you initially had with you. The public laws that govern service credit are Public Law 99-638, and then 104-106, and 107-107. So you'll notice in the previous slide we had 101-508. That dealt specifically with porting coverage. And 99-638 deals specifically with service credit. 104, 106, and 107, 107 deal with both issues. So again, these are some of the things that get a little confusing when you're dealing with NAF, is understanding all the public laws and what specifically are contained in each of them. Now, let's talk about porting coverage first of all, because that actually is pretty straightforward. And as far as porting coverage goes, under the very first public law, since that's the earliest one, 101-508, that went into effect on 11/5/1990, if you moved from a NAF to a covered appropriated fund position, either CSRS or FERS, if you move from NAF to there, if you're within, you can port your coverage. You can port your NAF coverage. Normally, say you started out in a NAF position, you're moving to an appropriated fund position, which normally would be covered by CSRS or FERS. You can retain the NAF coverage if you moved from a position within DoD to another position within DoD, or a position within the Coast Guard to another position within the Coast Guard. Or you moved, you could port your CSRS or FERS coverage to a NAF position, again, if you moved from a position within DoD to another position within DoD, or a position within the Coast Guard to another position within Coast Guard. You had to have done that between 12/31/86 and 8/10/96, and you would have had to have been vested in the initial plan that you were covered in and not have a break of more than 3 days. You would have a 30-day election period, and so that's really the key here. Okay, so that's what you need to be aware of. That you had to have been vested in that plan. It had to be after 12/31/86, a break of less than 3 days, and that move would have had to have occurred prior to 8/10/96. So remember how I told you there were going to be cheat sheets here? Well, here is a cheat sheet for you. If you can answer these questions, someone can port their coverage under Public Law 101-508. And did the employee move from a covered NAF to a covered CSRS appropriated fund, or vice versa, between 11/87 and 8/9/96? If the answer is yes, go to the second question. Was the employee vested in the retirement plan that they were covered under in the position that the employee left? If that answer is yes, then you go to the third question and you ask, was there a break in service of less than 3 days? And if that answer is yes, did the employee have a prior opportunity to port the NAF coverage? As long as they did not have a prior opportunity to port the NAF coverage as well, and you can answer yes to those other 3 questions, then they had a portability election under Public Law 101-508. So again, here's a handy cheat sheet for you to keep. Now, as far as porting coverage under 104-106, we've got another cheat sheet for you, but to walk you through the timeline, this one, they have a couple provisions, and this is where it gets a little complex too. They have some prospective provisions and some retroactive provisions, so we're adding a layer of complexity to this. Again, if you move from a covered non-appropriated fund position to an appropriated fund position, either CSRS or FERS, or vice versa, move from a covered appropriated fund position to a covered NAF position, and you made that move from 8/9/96, were vested in that plan, had a break of less than a year, and did that before 12/28/2001, then you have one opportunity each way to move. You must not have had a prior opportunity to port your coverage. You have a 30-day election period, and we actually did do a BAL on this. So if you refer to BAL 96-107 that was published on 8/20/1996, you have a lot of information there. Those are the prospective provisions. And again, we have another cheat sheet for you. So just like exactly what I just stated, did they move from a covered position under NAF or vice versa between 8/10/96 and 12/27/2001 to any agency and vice versa? Was the employee vested in the retirement plan? If the answer to that is yes, and was the break between the move from the NAF to the appropriated fund position 1 year or less? If the answer is yes, then did the employee have a prior opportunity to port their NAF coverage? As long as the answer, or their civil service coverage, if the answer was no, then they had an opportunity under Public Law 104-106. So again, you're going to notice that in all the instances that we looked at already, you can't have a prior opportunity to port your coverage. You only get one shot at this. Now, there is a retroactive provision to Public Law 104, 106 too. If the person moved from a NAF to any covered FERS or moved from any covered CSRS or FERS appropriated fund to a covered NAF position, okay, that occurred between 12/31/1965 and 8/10/1996. They were vested in the initial plan that they were covered under. Again, they had a break not to exceed 1 year, and they moved to that then. And the election deadline for that was 8/11/1997. Again, you're going to want to see BAL 96-108 for that. We did do a BAL on that as well. Those are the retroactive provisions. So it actually took it back to 12/31/65. So again, we're throwing a lot of dates at you guys. And honestly, I don't expect anybody to remember these things. I don't even remember them, to be completely honest. I'm always referring back to my notes. So that's why you've got the slide presentation here. You also have this handy cheat sheet, and you've got the BALs. So again, if you want to, if you work with us on a regular basis, it might be something worth committing to memory. Generally speaking, though, most HR specialists are not going to encounter this that often. And when you do, you're generally not going to encounter it every day. So you're probably not going to be committing it to memory. So again, keep the slide presentation handy, keep the cheat sheets handy. You've got the BAL references, and we're also going to give you the regulatory and statutory references as well. So you're going to have everything you need here. Again, as far as porting coverage for the retroactive provisions, I kind of already went over that with you. If they move between 1/1/66 and 8/6/96, then were they vested in the retirement plan? Was the break less than a year? For moves occurring between 2/10/96, did the employee have a prior opportunity to port either the NAF coverage? Again, because remember, these are the retroactive provisions. If they had one under the prospective provisions, the retroactive provisions don't necessarily give them a second opportunity. They only get one election opportunity, right? So the answer to that question would have to be no. And again, for the other one, for moves occurring between 2/10/96 and 6/9/96, did the employee elect to port either the NAF coverage or the CSRS and FERS coverage? If the answer to that is no, again, you're good. They would have a portability election under 104, 106. Now, Public Law 107, 107 was the last one that we had and regarding porting coverage. And that was a move from a covered NAF to any covered CSRS position, or a move from any covered civil service position or appropriated fund position to a covered NAF position. That would have occurred after 12/27/2001. Again, the person would need to be vested, and the break between the position that they were porting the coverage from to the new position would be less than a year. They would have a 30-day election period, and the most recent BAL on this is 02/102. Now, the thing is that, and this is really kind of cool here, is that Public Law 107, 107 actually eliminated the vesting requirement. If you remember, under all the previous election opportunities, you had to be vested. Under porting coverage under 107, 107, that vesting requirement was actually eliminated. So it pretty much rolled everybody else in under this. So if you refer to your cheat sheet here, did the employee move from a NAF position to an appropriated fund position or vice versa after 12/28/2001 and to any of the other positions? So they would move from the appropriated fund to the NAF or the NAF to the appropriated fund if the answer was yes. Was the break between the positions that they were moving to less than a year if the answer is yes? Did the employee have a prior opportunity to port the coverage? If the answer to that is no, then that's great. Then they actually do have a portability election under 107, 107. The thing is that, again, we're not requiring them to be vested in the initial plan. That's the big change with 107, 107. Now, key points. Elections are irrevocable and permanent. The effective date of the election is the day the employee entered into the new position. An employee who elects to continue NAF coverage may keep FEHB and FEGLI coverage. A NAF employee who elects to continue CSRS or FERS coverage is not eligible for FEHB or FEGLI coverage. An employee who elects to continue NAF coverage cannot participate in TSP, okay, because TSP is not a part of it. A NAF employee who elects to continue CSRS or FERS coverage is eligible to participate in TSP. Okay, so just be aware of that. Those are some key points. As far as porting coverage under Public Law 107, as far as what an agency has to do, you have to identify any newly hired employees who previously performed service with the NAF and determine if the employee is eligible to make an election to port the NAF retirement coverage. You need to verify with the NAF plan that the employee was a covered participant of the plan and confirm that the employee separated from a NAF position, okay? And you're going to see a sample notice in the BAL I referenced, which is 02102. For those of you who are new to HR, if you're referencing our BALs, our Benefits Administration Letters, and you find those on OPM's website, the first two digits of that BAL are the year. So when we're talking about 02102, we're talking about 2002 BAL, okay? Public laws are a little bit different because the public law represents the Congress. The first three digits represent the Congress that it was done under, which doesn't necessarily correspond to a year, but our BALs, the first two digits, are the year in which we published the BAL. And finally, provide a notice explaining the options in the elections from RI 38134 and document in the OPF that the employee received the election form. You're going to document that election by placing it in the right side of the OPF, or if you're using eOPF, you know, it's slightly different there. Send a copy of the election form showing the election to port the NAF coverage to the appropriate NAF office and to the payroll office. You're going to contact the personnel actions, you're going to correct the personnel actions retroactive to the date of the appointment to reflect the continuation of the NAF coverage. And the payroll office is going to follow guidance in the payroll office letter, which was 9606, which was published in 1996, right? And it's going to reference Public Law 107. If the employee appears to qualify to make an election under Public Law 104-106, refer to BAL 96107 or 96108, which address those concerns. Again, with all these bullets, this slide and this slide, as far as agencies go, you're going to want to pull this out too and keep this as a cheat sheet for yourself. Again, another cheat sheet that you're going to probably want to just pull out and keep handy are the references for porting coverage. The Title V references are right here, and the Benefits Administration Letters are listed as well. Also, the Code of Federal Regulations references on this slide as well. So again, these are nice cheat sheets to just keep handy because again, like I said, for most agencies, you're not going to be encountering this on a daily basis, so it is something you're going to have to reference and look up from time to time. Now, I want to skip the porting coverage questions in the middle of this presentation and save every question to the end. As far as the next question that we need to ask, and we're kind of moving into service credit right now, is NAF service creditable under CSRS and FERS, and can an employee pay service credit deposit to OPM to make NAF service creditable under CSRS or FERS? Well, there are laws that address that, as we talked about earlier. The public laws that deal specifically with service credit are Public Law, right here, the first one, the second one. You'll notice that the only difference here is the very first one, because the last two public laws, 104, 106, and 107, 107, also addressed portability of coverage. So again, when you're looking at this, you've got two public laws that address portability and service credit. Now, under 99-638, that actually is the earliest one. That was 11/10/86. NAF service that was included conducting arts and crafts, drama, music, library service club, youth athletic, sports, or recreational programs, including any outdoor recreation program for personnel of the armed forces, is what we're dealing with as far as giving service credit for. Okay, it had to have occurred after 6/10/1952 and prior to 1/1/66. It cannot be used in a NAF retirement benefit, and the CFR reference 831.305 is right here, and the person is covered under CSRS as of 11/9/56. So again, with this, service may be verified by records available at the National Personnel Records Center. So you're going to have to verify the service here. You're going to have to find out if there is service from the NAF retirement or from this NAF plan. Verified service should contain the individual's retirement record and public law 99-638, cited as the authority, and the normal service credit rules for non-deduction service apply to this period of NAF time. So we're treating it like non-deduction service in this time, right? So if you look at this, because of where it occurred, you're going to get credit for eligibility, you're going to get credit for eligibility and computation purposes, regardless of whether you pay a deposit or not. If you don't pay a deposit, we're going to calculate the amount that would be owed, and the annuity would be reduced by 10%. So again, normal service credit rules apply to this. Service credit for under Public Law 104-106 that went into effect on 2/10/96, the retroactive provisions, cover any period of time as of 12/31/60 after 12/31/65. Again, you're going to notice something here that the person would have had to have been vested in the retirement plan, and they moved from any NAF to a covered FERS position. The break had to have been less than a year, and there were no breaks in service, and that move to the appropriated fund position would have had to have taken place prior to 8/10/96. So again, if you move from a vested covered NAF to CSRS or FERS from 1/1/84 to 12/31/80 and between 1/1/65 and 12/31/86 and become FERS on 1/1/87, you must have previously elected to port coverage. You must not have previously elected to port coverage. The election deadline was 8/11/1997, and it may be extended. And again, BAL 96-108 has all the details here. Okay, now the retroactive provisions again. Upon election, any unrefunded employee contributions to the NAF retirement plan and any government contributions must be transferred to the Civil Service Retirement and Disability Fund. Any earlier refunded FERS becomes creditable. Now, the FERS redeposit is added to the deficiency before the actuarial reduction is made if we're going to credit that service and treat it like refunded time, okay? Now, with the new rules, with the NDAA provisions, if that's only going to happen if the person doesn't make the FERS redeposit for that prior period of refunded time. Because the rules changed for the NDAA provisions as of October 28th, 2009, you could actually make a redeposit for that period of refunded time and not have to worry about the actuarial reduction under Public Law 104-106. Now, again, if you move from a covered NAF to any covered FERS position, the normal service credit rules do not apply. NAF service creditable under Public Law 104-106 must be fully financed and cost neutral to the federal government. That means that it's not really going to increase your benefit. You're going to compare the present value factor of the benefit including NAF service credit with the present value factor of the benefit excluding the NAF service credit. And generally, employees are responsible for the difference between that. So if you wanted to use the NAF service, then we're going to look at the cost of what the benefit was if we used the NAF service, what the benefit was if we didn't use the NAF service, and basically we're going to bill the employee for the difference. Now, how are we going to bill them? It's generally going to be an actuarial reduction. So a service, now, before I even go into this, this is really the breakdown of how we compute an actuarial reduction. If any of you have heard my presentations before talking about service credit provisions as far as actuarial reductions go, what an actuarial reduction is, if you look on this slide, you'll see a present value factor. That present value factor is actually dependent on the age that you are. So what we're dealing with here is a present value factor that's linked to your age. And it's, generally speaking, we have an office full of actuaries here. And their role, one of their jobs, is to come up with these present value factors. The present value factor is the number of months you're projected to live based on actuarial tables, based on your age. So again, we've got somebody here. Again, we're not listing the age here, but if you look at those present value factors, they are linked to age, and that's what that is. That's the number of months you are projected to live based on actuarial tables. So we actually take the amount that you owe, divide it by the number of months you are projected to live based on these actuarial tables, which is the present value factor, and we come up with a monthly reduction to your annuity. So in essence, that's what the math is here. If we look at all the rules here, if we look at all the dollar figures, we're basically doing the computation. Again, you might want to refer to the math on the slide. Now, if you move from a covered NAF to a covered CSRS position, an election to NAF to CSRS benefit is also an election to port FERS coverage in any future move from a FERS position to a NAF position. Again, the NAF service credited to FERS under Public Law 104-106 is included in the FERS annuity supplement computation. So in the example we have here, we have somebody who was in a NAF plan. They were vested. They had a break of less than a year. They moved to FERS. The election to FERS, they elected FERS credit for the NAF service, and then they moved to a NAF position. Okay? So again, we've got somebody who moved from a covered NAF to a covered FERS position under Public Law 104-106 from 12/31/1965. They were vested. They had a break of less than a year. Then that occurred between 6/10/96. So again, we're looking at the same thing. And your references here are the CFR 847-421 to 423. Again, we've got Part 847, Subpart F, and again, BAL 96-108 is another reference for you. Now, again, Public Law 107-107 is very similar in that this had to be cost neutral to the government too. So we're dealing with another provision here where it's not actually going to increase the annuity, okay? So it applies to NAF service, not creditable under any other provision of the law. CSRS and FERS employees who qualify for a deferred retirement without NAF service may elect to credit the NAF service to qualify for an immediate retirement. So again, if you were a CSRS or a FERS person, you separated before you were actually eligible to retire, but you would become eligible at some point later on. That's what we're talking about when we're talking about a deferred retirement. Most of you probably already know that. That being said, if the person was eligible for a deferred retirement, but adding the NAF service would give them credit for an immediate annuity, then they can get credit for this NAF time. Now, the NAF service cannot be used in a NAF retirement benefit. Again, another important point, right? So the NAF service cannot be used in a NAF benefit in order to get credit for it, because generally speaking, you can't get credit for a period of service under another government retirement system towards your CSRS and FERS time if it's creditable under the other government retirement system, and if it's going to be used in that benefit. Now, the NAF service creditable under Public Law 107-107 must be fully financed and cost neutral to the federal government, as I said. So in this example we're looking at, you compare the present value of the benefit, including the NAF service, with the present value of the benefit excluding the NAF service, and the employee is going to be responsible for the difference. So again, similar to what we saw in the prior public law, right? No money is transferred from the NAF system to the Civil Service Retirement and Disability Fund. The employee cannot pay a deposit for the NAF service. The difference is paid via actuarial reduction. NAF service credit will not result in a higher annuity benefit. Okay, that's really important to be aware of. NAF service in this situation under Public Law 107 and 107, again, will not result in a higher annuity benefit. It has to be cost neutral. So let's look at another example here. When we've got a service credit example here, the difference between the present values of the annuity with the NAF service versus without the NAF service, the deficiency is $60,239.70. We already talked about what a present value factor is based on this person's age. We divide the amount by the present value factor, and that is the amount that we're going to reduce the annuity. So the monthly amount would be $1,208. With the NAF credit, we actually reduce that by the actuarial reduction. So you see that it basically comes out the same. A lot of people somehow think that, a lot of employees somehow think that the NAF service is going to increase their benefit. But under both of these last two public laws, it doesn't increase the benefit. So just be aware of that when we're talking about service credit issues. And again, I guess the person who developed this initial slide presentation really wanted to drive the point home, as you notice in the next 3 bullets on this slide. NAF service will not result in a higher annuity benefit. Okay, so just be aware of that. Again, you've got your references here. We've got, I'm not going to read through them all for you. You've got them on the slide. Again, it's a nice little cheat sheet to pull aside and keep handy, because if you ever need to reference, if somebody is actually looking for, sometimes you'll have employees who will want the specific either legal or regulatory reference, or will want to see OPM's guidance on that. So again, these references are really handy for you to keep around, just because a lot of times I have HR people for the agencies that I'm responsible for who call me and say, you know, do you have the reference for this? Or, you know, depending on what the situation is. And they're all right here for you. So just be aware of that. You've got them handy all in the slide presentation. Now, some key points when we're talking about service credit. This is, again, a nice little cheat sheet to keep handy. The primary advantage for electing NAF credit under either 104, 106, or 107, 107 is it allows the employee to retire earlier. Because remember, in both those cases, it's not going to increase the amount of the annuity. It's just going to let the person retire earlier because you're giving them credit for that service. Under 104, 106, the NAF service credit generally will only enhance the amount of the annuity if the employee qualifies for an immediate retirement without the NAF service. Under 107, 107, the NAF service will never increase the amount of the employee's annuity. And the FERS annuity supplement is not payable to retirees who use NAF under Public Law 107, 107 to qualify for retirement, because they weren't eligible for the annuity supplement if they were using it for service credit under 107, 107, because they were using it only in the case where they were separating as a deferred retirement, but used the NAF service to qualify for an immediate retirement. So because they weren't eligible under the appropriated fund rules initially, this NAF time is not going to give them the annuity supplement. Now, as far as service credit elections under 107, 107, what the agency needs to be aware of, what you guys need to actually be aware of as far as actions you need to take, you have to advise the employees with NAF service that the credit may only be made at the time of retirement if the NAF service is needed to qualify for an immediate annuity. Okay, so we're not going to make that determination until the person is actually going to retire and they need it to qualify for an immediate annuity as opposed to a deferred annuity. You're going to advise the employee how much NAF service is needed to qualify for an immediate retirement, and contact the appropriated NAF employer to verify the NAF service. Compute the annuity estimate showing the annuity rate if the employee elects NAF credit under Public Law 107-107. Compute the additional estimate showing the amount of immediate annuity without the NAF service, assuming the employee continues working until they qualify for an immediate retirement. If the employee does not have the option of continuing to work, calculate a deferred retirement without the NAF service. Complete Part 1 of the NAF Service Credit Election Form, which is RI 38145, and then give that form to the employee. Now, if the employee elects NAF service credit under CSRS or FERS, you're going to send the election form with the verification of the NAF service and flag and the flag card from BAL 03102 with the retirement application package. Retirement information for employees electing NAF service credit should not be sent through an electronic feed to OPM, okay? You're going to need to actually send that form and flag it and attach it to the application package. Notify the appropriate NAF plan of the employee's election as well. At this point, excuse me, I'm just getting over a cold, so I apologize. Before we actually open the floor up to questions, fortunately, I actually got contacted by a friend of mine, one of the HR people that actually works at NAF, and she sent me a list of 4 common questions that usually come in, so I wanted to share them with you. Thank you, Donna, for sending these. First question that she said she gets quite often: are the election forms for FERS coverage used for all FERS elections, including FERS Ray and FERS Fray? And that is an excellent question. The answer is yes, the same forms are used. The contribution level or the contribution level differences do not affect portability. Okay, and that's something I want to mention while I have you guys all on the line or on screen with me right now. This is a very good point. FERS Ray and FERS Fray are essentially FERS with enhanced contributions. I want every HR person, whether you're a benefits officer or whether you're in the field, to understand this, that FERS Ray and FERS Fray are just basically enhanced contribution amounts. It's still FERS. It's not a separate retirement system. We're not treating it any differently. It's just that the employees under FERS Ray and FERS Fray are paying higher contribution amounts. And the reason I emphasize this is I just did a FERCA class and that same question came up. So when you are dealing with FERCA as well, when you're looking at somebody who should be covered under FERS, that includes FERS Ray and FERS Fray. Okay, so again, Ray and Fray, just enhanced contributions, but they're still FERS. Second question that we end up getting: where can Human Resource Office staff find retirement portability election forms? The answer is with the RI 38144, the election to retain CSRS offset or FERS retirement coverage as a result of a move from a civil service position to a non-appropriated fund position on or after December 28, 2001. Great name for a form, right? The election to retain non-appropriated fund is, okay. It's in OPM's BAL. It's in the archive BAL website, and the BAL is 02102. It was published on May 1st, 2002. So if you're familiar with our BALs, if you go to BALs that were published in the year 2002, you'll find it there. Question 3. If an employee who elected to remain in NAF retirement system moves to civil service law enforcement position, can he or she switch to FERS coverage in order to be covered by the special law enforcement provisions? The answer to that is no. The employee made an irrevocable election. Remember, these NAF elections are irrevocable. Once you port your coverage, that is it. You get one election. These elections are irrevocable. It's a one-time thing. Okay, so they are going to be covered by NAF once they elect to port their NAF coverage. That's it. Okay, and finally, Employees who move between NAF and civil service positions within DoD without a break in service of more than 3 days are eligible for transfer of annual leave balances. May they instead receive a lump sum payment for accrued leave? The answer to that is no as well. Employees who are eligible for transfer or annual leave balances may not receive a lump sum credit for annual leave. Now, that leads me very nicely into the next section where I want to kind of talk about some miscellaneous things where we're getting into leave and some other issues. Again, if you've got your questions, you can, because I know we're getting into some other things here now, dealing with miscellaneous questions. If you have questions regarding portability or service credit, I'm going to answer those in just a few minutes. You can kind of start sending those. We are going to address those. So in agency, but I want to address some specific things here, some miscellaneous things here. In agency reorganizations, reductions in force, employees with prior NAF service may be able to use their NAF time to qualify for a discontinued service retirement. The present value factors, this needs to be updated. They just changed again fairly recently, so just be aware. That was actually in our latest annual changes BAL. Discount factors last changed on 10/1/2004. See attachment 3 of the Benefits Administration Letter. As far as reductions in force, for DoD NAF to DoD appropriated fund, if the break is less than 3 days, employees are entitled to credit for NAF service if they move on or after January 1st, 1966 from a DoD or Coast Guard NAF position to a DoD Coast Guard position, civil service position without a break of more than 3 days, okay? And that is codified in 5 U.S.C. 3502A4C and in Public Law 101-508 as amended by 104-106. As far as within grade increases go, employees are entitled to credit for NAF service for within grade purposes if they move on or after 1/1/87 from a DoD or Coast Guard NAF position to a DoD or Coast Guard civil service position without a break of more than 3 days. Now again, remember they have to go from DoD to DoD or Coast Guard to Coast Guard without a break of more than 3 days, and that in situations like that, in those cases that NAF time would count for within grade increases as well. Now annual leave. Again, employees who are entitled to credit for NAF service if they move on or after January 1st, 1987 from a DoD or Coast Guard NAF position to a DoD or Coast Guard civil service position without a break of more than 3 days, they are going to get credit for the annual leave under 5 U.S.C. 6312. Okay, so just be aware of that. And again, it's Public Law 101-508. As far as transfer of leave goes, annual sick and home leave of NAF employees transfers to the civil service position if they move from a DoD or Coast Guard NAF position to a DoD or Coast Guard civil service position that is subject to annual and sick leave without a break of more than 3 days. So just be aware of that too, the leave transfers. And that really refers us back to this question number 4. If you get a lump sum payout of leave, of course, you got the payout, so that's it. But if you didn't get the payout leave and you wouldn't get the payout because the break is less than 3 days, that leave will transfer to you. Okay, and now we're going to open up the floor to some questions.
Thank you very much, Mike. Our first question comes from Sam. What is the vesting time period for porting coverage under NAF?
The NAF retirement plans have their own vesting requirements, so you would have to refer to that NAF plan.
How do we, the next question comes from Linda. How do we determine if the employee is vested?
Okay, same thing. You're going to have to reach out to the NAF plan and find out what their vesting requirements are.
In second part of that question, how do we determine if the employee had a prior opportunity to port their coverage?
That should be in the OPF. It should be documented. That definitely should be in the OPF. You also may be able to tell by the 50s If you happen to know a position was covered by CSRS or FERS, and clearly the person is in NAF, then there was a portability election that was done in a situation like that. If you're moving within the same agency and you can actually access that information, you may be able to determine it that way as well.
All right, our next question comes from Sandra. She asks, does NAF time count in the leave service computation date?
Well, if it's going to be creditable, if you're actually going to count it for annual leave, and that is a question that I would have to refer to our pay and leave folks, but for an official answer, but my assumption is because you do get credit for it if the break is 3 days or less, and if you move from a DOD NAF to a DOD appropriated fund position within either DOD, or you do it from Coast Guard to Coast Guard and there's a break of 3 days or less, that annual leave continues over. It would make sense that because that is the leave SCD, that yes, that would carry over.
Okay, I have a question from Cheryl. If an employee moved from APF to NAF to APF and then had sick leave, quote, on the books, where does the sick leave go? Can the NAF organization send the sick leave to OPM if the employee is still working?
Now we're getting into some really complicated, like individual questions. What I would suggest, and this is because, again, as you saw, this gets kind of complex. I would suggest that you contact your specific liaison. If you're the headquarters benefits officer, definitely forward it to your headquarters benefits officer first. If not, send it to your specific liaison. Here at OPM, we have a list of those for you guys. Your benefits officer definitely knows who your liaison is. And send that to us with the specific situation, the specific dates as well, because as you saw, we've got lots of different dates going on here. And we're going to need information as to whether or not they ported coverage as well and all that stuff. So definitely when we start getting into these really complicated ones, send the specific information to your liaison and we'll work with you individually on that.
Okay, next question comes from Sam. What is meant by quote, retirement benefit when used in the statement that service cannot be used for retirement benefit?
Okay, I'm not quite sure where we were on that slide, but what I suspect that we are talking about is that it's not going to increase the amount of your benefit. I'm thinking you're talking about Public Law 107, 107, where it has to be cost neutral. And in those cases, when Congress passed those laws, they basically said that, yeah, you can use this NAF time, but it's not going to increase the amount of your benefit. It's not going to increase the dollar amount that we're going to pay you. It's going to give you eligibility if you didn't have it before. So it's really not going to increase the amount of benefit that you're going to be receiving. We're going to apply an actuarial reduction to make this cost neutral to the government so it doesn't cost the government anything.
Okay, the next question comes from Ernest. Can you clarify the difference between covered or vested NAF service versus NAF service only subject to FICA? Is this considered non-covered or vested service for NAF?
Again, the NAF plans have their own rules, but NAF FICA time generally, they may have some rules depending on the NAF plan that would give them potentially creditable service for that FICA time. As you know, for our civil service and for our FERS time, when we apply the 5-year test, under the appropriated funds system, we have FICA time, and it is treated as potentially creditable for the 5-year test if the person pays a deposit for it. As far as the NAF plan goes, because OPM does not administer that NAF plan, we would not be able to speak to that directly. You would have to actually talk to the specific NAF plan about it. But they may have some provision within that retirement plan that allows for that FICA time to count towards either the vesting requirement or allow that person to pay a deposit for that time to give them that vested amount of service. So again, I wish I could give you an answer, but we're dealing with a plan that OPM doesn't administer, and there's more than one NAF plan. So unfortunately, I can't give you a specific answer to that.
A good follow-up to that is from Jennifer. She says that you mentioned in your presentation we are to contact the NAF plan or NAF employer. Is there contact information available for these?
I actually don't have that. The person that I have actually contacted before is the benefits officer for NAF, and her name is Itzel Santana. She's at the Department of Defense. There may be, if you have an employee that has NAF service in their OPF, there should be something, there might be some contact information there. I'll tell you what, I'm going to reach out to Itzel, see if I can actually get a current list of contact information for the NAF plans, and see if we can actually, whenever we post this, get this out to everybody.
Okay. Let me see. We have a question from Erica. Oh, never mind. We do not have a question from Erica. We have a question from Margaret instead. How do I advise employees who just transferred to FERS covered positions from NAF? Is the employee eligible for portability?
As you saw with the slides, I couldn't tell you without specific dates, without anything like that. We would have to look at you know, did they have prior opportunity to port their coverage? What happened? I mean, as you saw, we waded through a lot of this material. Again, if you are having a question about it, go through the cheat sheets that I gave you in the slide presentation. If that still doesn't answer your question, again, contact your OPM liaison and we will work with you. We're going to need specific dates. We're going to need the service history. We're going to need all of that. And again, remember under Public Law 107, we're not talking about porting coverage, we're talking about service credit. As far as the service credit issues, that's going to be a whole separate discussion.
Okay, this is, we've had a few questions on this, so I'm just going to kind of group these all together.
Okay.
Can an employee who just moved from a NAF position get credible service for leave accrual in a non-DOD agency?
I don't believe so. You would have to move from a DOD to a DOD or from a Coast Guard to a Coast Guard in order to get the leave to transfer over.
Okay, now this question comes from Faye. What if there is no documentation is about whether an opportunity has been given or not for them to port it?
You're going to have to go back through the service history and try and find out if there was. Unfortunately, you know, we end up dealing with that a lot in retirement cases as well when they come to us. A lot of times you're recreating history. For those of you who've worked with elections of FERS coverage or worked with FERCA before, when we start dealing with FERS election opportunities, it's the same kind of thing. A lot of times we're trying to have to recreate history, so you're going to have to keep going back and try and see what you can find as far as history goes. You might actually be able to find something from the National Personnel Records Center as well.
Okay, this is a similar question, just a small variation here. You keep talking about DOD NAF to DOD Civil Service. Do most of these rules apply if they move from DOD NAF to a different agency? Say they move to the VA and only have less than 3 days of break in service for that change?
Generally not. I mean, again, we're talking about which public law you're dealing with here. So as you saw when we went through the whole presentation, there are specific, and it depends on whether you're talking about porting coverage or you're talking about service credit.
I don't know.
Okay, that's actually going to, again, you know, you're going to have to wade through, and I'm getting a trend here. So let me kind of walk you through what you need to isolate. Again, it's kind of on the cheat sheets, but I think this will actually help everybody. First thing you need to isolate is, are we talking about porting coverage and are we talking about service credit? okay? Two completely different things. So that's the first issue that you're going to deal with. You're going to separate those out. Then, the second thing that you're going to have to do is go through the public laws and look at the whole service history. What I would suggest, and this is just what I would do if I was working on this, is once you get the person onboarded, once they come to you, I would reconstruct their entire service history, do almost like a certified summary of federal service. You may even want to use the FERC. Even though NAF doesn't qualify for FERCA, you may want to use something similar to a FERCA eligibility worksheet, because that's very similar. That's something that you can put your entire service history on, break that whole thing down, and then go through each public law and determine whether or not they were either eligible to port their coverage or they were eligible for service credit. And that's what I would suggest you do for every employee who either comes to you with NAF service initially or who came from an appropriated fund to a NAF. That, I think, will solve a lot of your problems. That'll answer a lot of your questions because, again, as you saw, this is really complex. We're dealing with two completely different issues here, portability and service credit, and then we're dealing with 4 public laws that treat it differently.
Okay, this is more of a retirement processing question. If retiring from FERS with a prior NAF component, should the retirement package be sent through the normal channels?
Okay, so they had a prior period of NAF service, and they're under FERS now. Then I guess the question would be, are we talking about giving credit under Public Law 107, 107? Because if that's the case, then again, remember that's a person who would have initially only been eligible for a deferred annuity, but used the NAF time to get credit for eligibility to retire on an immediate annuity. And in that case, yes, you do have to document that. All the instructions are on one of the sheets that I gave you with the bulleted list. In fact, let me find it here. If the employee elects NAF service credit, you're going to flag the case. There's a flag in BAL 03102. So again, just be aware of that. Again, everything is pretty much in the slides here. I know we went over this stuff kind of fast. Again, what I would suggest that everyone do is when you encounter a case with NAF service, because again, when you start getting into the case-specific ones, it gets a little challenging here without having all the dates and understanding which public law it's under. Walk through all of these, and if you have any questions, contact your agency liaison with the specific dates, the specific lengths of service, specific length of the breaks in service, if there are any, and we'll help you with all that. We'll definitely help you with any of the NAF cases that you have, because we realize it can get really complicated.
Okay, and just there's some more questions that you've already answered, so it looks like that's all we have for you today, Mike.
Okay, great. Well, thank you guys for tuning in, and I look forward to talking to you again. I'm probably going to be talking to you about some other issue.